Did the U.S. Supreme Court overturn New York versus Class? All right, hey guys, my name is Anthony Bandier. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing the Roadside Chat. I got a little email here on my phone. Let me just kind of read it. It's officers from Arizona. He says, look, in reviewing some department literature from some reference material for search and seizure, they have in the material a administrative search section. And it references New York versus Class, which is a U.S. Supreme Court case from 1986, stating an officer can open a vehicle's door to obtain the VIN during a lawful traffic stop. Would a recent case of United States versus Jones invalidate this, right? Okay, so let's kind of go through this. We got to define some cases here. So New York versus Class is a 1986 case that basically held that if an officer during a traffic stop cannot read the VIN, he or she is allowed to open up the car door to read the placard or to move the piece of paper, right? But I think a lot of officers really misunderstand that case. They think it holds holds the proposition that we can just open car doors to look at VINs. Like even without a traffic stop, if we want to do a VIN inspection, we can do that. And I've actually had officers do that. I had one officer he was in an apartment complex, and he saw that the VIN was covered up on a vehicle, so he opened up the car to look at the VIN placard. That is unauthorized. That's not lawful, unless he had probable cause that the vehicle was stolen, right? Which he did not. The VIN was covered, right? So don't misinterpret it. This is only when A, the vehicle's been detained, right, seized lawfully, like a traffic stop, and B, you cannot read the VIN from the outside, or the VIN on the outside is probably fraudulent, right? The other case that the officer is saying, all right, so, okay, fine, that's what 1986 case held. What about this other case where the Supreme Court said that physically intruding on vehicles with the intent to gather information is a search under the Fourth Amendment? Well, Jones does not actually, it's compatible with Class, right? So, yes, open the car door is a search. Now, the court said that a person in Class, they said a person does not have a reasonable expectation of privacy in the VIN information. But don't misunderstand that. They're not saying that a person doesn't have an expectation of privacy inside their vehicle where the VIN is. Getting into the vehicle will be the problem. The VIN itself there's no expectation of privacy, but it doesn't mean you can just open up car doors, right? So when the Supreme Court says that physically manipulating these cars and opening up doors and putting GPS trackers on them and so forth is a search, it's still authorized under Class because Class is the exception. Class is saying, hey, look, if you need to read that VIN during a traffic stop, yes, you can open up the car door, which would be a search, but you can do it if it's the least intrusive means and so forth. So at the end of the day, maybe a few things going on here. So can you open up the car door to read the VIN placard? Only if the vehicle has been seized and only if you cannot read the VIN from the outside. Is opening the door a search under Jones? The answer is yes, but again, Class is still good law. All right? Does that make sense? If it doesn't, tell me in the comments below. I'll kind of clarify this. But do me a favor before you leave. Hit the like button. I really appreciate it. Subscribe to the channel. See what I'm doing and kind of keeping up to date. And share with your friends. It does help the channel. All right? Spread the video around. Until next time, my friends, you stay safe.